Just to introduce myself a little bit more, so I'm a partner at MinterEllisonRuddWatts along with Janine. Whereas Janine's gig is more, we're both litigators, but whereas Janine's gig is more construction, mine is insolvency. So what that really means is I, for my sins, end up spending an unhealthy amount of my time with the likes of Andrew Mackay there, doing this sort of stuff. So this works as it should, which isn't looking promising. I'll try this. What I'm going to do is give you a bit of a sort of an overview of the insolvency or the formal insolvency, landscape that will apply in an insolvency in the construction context, or indeed in any context for that matter, because these are standard formal insolvency processes. So it's just to give you a bit of a feel about, from a legal perspective, what the role of the relevant insolvency practitioner is, how they operate, what the rights of you or anyone else, any other stakeholder in an insolvent enterprise is, how they differ in terms of the different types of regimes, what the interplay is between them, some of the powers and the duties that apply and all of that sort of thing. A lot of it is, if you like, to set the scene for when Andy comes back to talk to us from a practitioner's perspective as to how, as a receiver or as a liquidator or as an administrator, he might go about administering the insolvency of the particular contractor or developer or principal or subby or whoever it may be. So that's sort of stage one of what I'll talk about. The second part is just to talk a bit about retentions, talk about the existing regime that's been in place since 2017 and some of the issues that generated, which then spawned the new regime, which was passed into law in April this year, and kicks in on the 5th of October, so a few weeks away, to kind of strengthen the intention around the retentions regime and talk about how that might operate, or how it will operate, should operate. So, very, very quickly, liquidation first of all. So, liquidation is the scenario where it's basically the death rattle of a company. If you're in liquidation, there's no going back. There might be a receivership, there might be an administration, which we'll get to, not with a liquidation. The purpose of a liquidation is for someone like Andy, as a liquidator, to be appointed to assess the claims of all the different stakeholders, creditors and the like in the company, work out what their entitlements are, then collect in whatever assets they can collect in, selling any assets that the company holds, pursuing debtors to try and get money back in, exercising certain particular rights that liquidators and only liquidators have. Andy mentioned one of them, voidable transactions or voidable preferences. In other words, where prior to liquidation you've received a payment from the company, the company's put into liquidation, the liquidator comes and asks you to pay that money back. And the reason you're asked to pay that money back is because underpinning the whole concept of liquidations and insolvency law generally is because there isn't enough assets to go around to pay everyone. Everyone should share equally in the pain and get an equal payout in the liquidation process. And if you've been paid before liquidation the full whack that's owing to you, then you're getting an advantage as against other creditors, which should be rectified. So that's that sort of mechanic there. What happens when a liquidator is appointed? The liquidator has the control of all the company's assets. No longer does the directors have control over the company and its assets. They remain in place, but they are displaced when it comes to the authority to deal with those assets by the liquidator. There's, on appointment of a liquidator, a moratorium that applies. And what that means is that someone can no longer sue the company, or if there's a legal proceeding that's been commenced against the company, it can't be continued during the liquidation unless the liquidator consents to that or the court gives leave for that to continue. Anyone with a claim against assets, unless they're a secured creditor holding security over those assets, then they can't enforce those claims against those assets. So the purpose of all of that is to kind of hold everything in place to enable the liquidator to administer the company's affairs and the company's assets in accordance with the specific regime as I described before. Gather in the assets, distribute them in accordance with a particular waterfall to pay creditors in accordance with their respective entitlements. Now, as I said before, liquidation is the death rattle of a company. It's unusual, it's not impossible, but it's unusual that a company that is in liquidation will continue to trade. Normally what will happen is it will shut its doors and any assets that are held will be sold off in effectively a fire sale nature, just to get in cash as quickly and as inexpensively as possible. Now, I think I've covered most of the things on that slide, so if we just push on a little bit more. So I've touched on some of this as well, the process itself. The liquidator calls for claims. So you'll be asked as a creditor to submit what's called a proof of debt or a creditor's claim form, where you complete that and you say, this is how much is owed to me, this is what I claim against this company, as at the date when the company's put into liquidation. Here's all the supporting documents. Andy and his team will go away, they'll go through all of that and vet it and make sure that it all stacks up. And if it does, accept that as your claim admitted in the liquidation. If it doesn't stack up, they might reject it, they might go back to you and sort of tweak it, reduce it, or something of that sort. But there's that process to go through. As I mentioned, he'll then go and cash up the assets and bring them in. I've talked about some of the tools that he might deploy to do that, the avoidable transactions and that sort of thing. Another one might be to sue directors, as Andy and his predecessor in his role as liquidator of Mainzeal have done for 8 years in the Mainzeal liquidation that you all know about. All of these things are looking at means to try and bring in money into the pot to be able to then distribute it out. In terms of that distribution process, there is a waterfall that applies. Insolvency law respects claims to property, whether that's property that doesn't belong to the company but belongs to someone else, or it's held in trust, for instance, which is we'll get onto with the retentions when we talk about that, or whether it's property that is subject to a security interest in favour of a secured creditor. In all of those things, a liquidator can't really touch those assets. They're not within their jurisdiction to be able to deal with. So any assets that are subject to a security, with one exception, a secured creditor can take those assets and realise them and repay the secured debt to the extent they're able to do that. If there's any surplus available, that goes into the pool for unsecured creditors, but secured creditors first. There is an exception, and that is for certain types of asset. Inventory, not really applicable in the sort of scenario we're talking about here, but accounts receivable as well. Those types of assets are available in a liquidation to pay preferential creditors, certain creditors whose rights are greater than any other unsecured creditor. And they are, there's a list of them, but the general ones are our employees for employment entitlements that are outstanding up to a certain cap, and the IRD for GST and PAYE. Some other bits and pieces, but they're the main ones. And then whatever's left, after paying the likes of Andy's costs and those of his lawyers that he engages to sort of run the whole process, that's what gets distributed equally amongst unsecured creditors according to the value of their claims. And at the end of all of that, when everything's cashed up, everything's paid out, the final sort of death throw of the company is that the liquidator will file annual accounts with the registrar of companies, and the company will be removed from the register. It will legally die and be at an end at that point. I mentioned there's a number of powers that a liquidator has. Some of them I've already covered. One of them, which was referred to earlier, was disclaimer. So companies contractually obliged to do something to you or someone else, and you have some rights against the company there. A liquidator is entitled to look at that and say, well, actually, there's no profit in this for me to have this company discharge that obligation. And in fact, by continuing with this obligation, this is a distraction and this is a cost to the liquidation, which, prevents me from being able to efficiently distribute assets to pay off creditors. So the liquidator can say, I'm disclaiming this contract, it's unprofitable, and as a consequence of that, there's no further obligation contractually to perform that contract. The other party to the contract has a right to claim damages. They can submit a claim form I mentioned before and join the queue of everyone else and share equally with everyone else for whatever may be paid. But the contractual obligations come to an end. So that's the specific power that only a liquidator has. Mentioned setting aside voidable transactions, voidable charges, there's securities, setting aside voidable dispositions, where the company has, after an application has been made to the court, for instance, to appoint a liquidator, if the company has disposed of its assets in a way which is not in the ordinary course of its business, then those disposals are automatically able to be clawed back as a voidable disposition on the appointment of the liquidator. Now, one thing I didn't cover right at the outset was how a liquidator is appointed. Typically, it's either of two. There's possibly three, in some instances four, but typically the main ways in which a liquidator is appointed is either by a special resolution of the shareholders of the company or by some other party, typically a creditor, taking a court action, issuing a statutory demand on its expiry, relying on the presumption of insolvency that gives rise to, filing an application for liquidation with the High Court, getting an order appointing a liquidator to the company. So that is liquidations. Voluntary administration is, if you like, at the other end of the spectrum to liquidation. Voluntary administration is a regime. It's relatively new in our insolvency law. We adopted it from Australia. It came in around about 2006. And the whole theory behind it is instead of tipping a company into liquidation and its death, if there's an opportunity to try and salvage a company, to be able to turn it around, to try and rescue it in some sort of way with the blessing of its creditors so that it can continue in business in a better form, or if not that, to at least return more to creditors than might be possible if the company was immediately put into a liquidation in terms of a dividend, cash in hand. Then voluntary administration allows an administrator to be appointed. Now again, that'll be someone like Andy, an insolvency practitioner, but their role will be slightly different from that of a liquidator. Their role will be to, first of all, try and understand the nature of the business, try and work out whether or not there is a realistic potential for turning that company around, and if there is, to put a report to creditors at a meeting of creditors, a critical meeting called a watershed meeting, at which creditors can vote on whether or not they think there's something of worth in the proposal that's been put forward. It's called a deed of company arrangement, if there's a proposal put forward, and if they think there is, to endorse it, and the company is then administered according to that contractual document, that deed of company arrangement. Alternatively, if the administrators feel that there isn't a realistic prospect of trying to turn this company around and putting that sort of a proposal to creditors, then the alternative is to put the company into liquidation, and creditors will vote to do that. And at that point, we go back to the scenario I've just spoken about, and all of those rules apply. So voluntary administration is just that opportunity to try and see if there is a potential to deliver a better outcome ultimately for creditors than putting the company into liquidation from the outset. To do that, it needs a breathing space for the company to continue to be able to operate whilst a plan is developed and put to creditors. And to give that breathing space, there's a moratorium, as we've talked about in the case of a liquidation, so too in a voluntary administration. There's a moratorium put in place which prevents parties from taking action against the company. And it's actually stronger than in a liquidation because it also prevents an owner of property, a lessor, so if you're the company in liquidation, you've leased assets from someone else, that lessor is unable to come in and pick up that digger or whatever else that's been leased during the course of the administration. So too, with one exception, a party with security over assets. In a liquidation, they can go and do what they like in terms of their security over the assets that they hold the security over. Not in an administration unless they have a security over all the assets of the company. So the holder of a general security agreement, that sort of thing. They still retain some rights to be able to appoint a receiver, for instance, which we'll talk about next, over those assets. But otherwise, if they don't do that, then they too also are having to stand by and allow the administration to run its course and then to vote on whatever proposal might be put up at the watershed meeting. Now, because of these moratoriums, because it's holding people at bay from exercising their contractual entitlements, including to property they own, there's a tight time frame within which an administration is supposed to run. So there's an initial meeting of creditors to confirm the appointment of the administrators. There's then that watershed meeting I spoke about, which is another sort of 20 to 25 working days after that. So it's a relatively short period of time. But there is the power under the Companies Act, which governs voluntary administrations, and it is quite typical in voluntary administrations that an administrator will go to the court to get an order to extend that period simply because the practicalities of the business might mean that you need a bit more time to work your way through it, and that often happens. But the theory is that if you're being held at bay and exercising your rights, it should be for the shortest possible time in fairness to you as a creditor of a company in administration. So I spoke about the moratorium there. As with liquidators, the director's role is they're still there, but they just can't do anything. And that was that, I think. So receiverships, the third of the three beasts that we talk about when it comes to insolvency, formal insolvency processes. A receivership is, again, an insolvency practitioner such as Andy, who, though, has been appointed by a secured party and been appointed under a right that's given in that security, so it's a contractual right that if it's not in that security document, can't be exercised, but typically it's there. The secured party, when there's a default on the term under their loan, can appoint the insolvency practitioner to step in, take control of the assets over which they hold security. And that's the extent of their rights, if you like. It's only to the assets over which security is held. If there are assets over which security isn't held, they can't touch those. And again, that's relevant when we come to talk shortly about the retentions regime and some of the problems that have been experienced in relation to that to date. So the receiver comes in, they're appointed by the secured creditor. They typically, unlike a liquidation, they will trade the asset if they can. And they will do that because their primary duty is to act in the best interest of the secured parties appointed them, which typically comes down to repaying as much as possible on that secured loan as you can, getting the best price you can for the assets, and if you can sell a business as a going concern, you maximise the value that might be available. To do that, you need to trade on. So receivers will typically try and trade on for a period of time to try and keep things alive, keep that value maximised whilst they run a sale process to see if they can get the business sold for that maximised value. In terms of the powers that a receiver has, the receiver doesn't have the powers that I talked about before in relation to a liquidator. The receiver's powers are powers to deal with the secured assets only, and they're powers that are contained either in the security they've been appointed under, or the Receiverships Act, which is the governing legislation which deals with receiverships. In operating the business, trying to maintain that going concern value to see if they can get a sale away. They need obviously to continue to employ staff to keep the business going. Typically they will try and reduce the staff to the key ones. They've got a 14-day period in which to determine who they may be and to terminate the contracts of everyone else and put the ones they want to retain on receivership contracts to continue to operate the business. Receivers will also look carefully at other contracts as well to see if they're to be retained or not. They don't have the power to disclaim contracts, which a liquidator has, but they could choose, from a commercial perspective, to cause the company just simply not to perform its obligations. That will be a breach of the contract. The claim will be an unsecured claim, but the receiver's focus isn't on unsecured creditors, it's on that secured creditor who they want to repay. So they're not too concerned if there's an unsecured claim that results because they cause the company not to perform that contract. Receiver's duties, touched on one of them, the primary one if you like, which is to act in the best interests of the secured creditor. So unlike a liquidator or an administrator whose constituency is creditors generally, and in particular unsecured creditors, the receiver's constituency is that secured creditor who appointed them. It's an enforcement technique more so than an insolvency process, if you like. In doing that, the receiver has to be mindful of the fact that there are others standing on the side who are impacted by decisions that they make in dealing with assets. So there is a duty that a receiver has when they go to sell assets to take reasonable steps to get the best price reasonably obtainable for the asset being sold, so that if there is anything over and above the amount that's owing to the secured creditor, that's preserved to be able to pay other subsequent ranking secured parties, or to pass on to a liquidator if one's appointed to deal with, to pay unsecured creditors. Typically you will have these three regimes overlapping. You will have a liquidation and a receivership and an administration. Less common, but theoretically possible, a liquidation and an administration. And that's because they each have their own particular facets, as we've gone through, and each have their sort of particular focus in terms of the role of that particular insolvency practitioner. And there are various rules at play around who prevails in different circumstances. As a general rule of thumb, the receiver will prevail over an administrator or over a liquidator in respect of secured assets. Because that goes back to the point I made earlier, which is insolvency law pays particular respect to interests in property, to security over property, and that's the receiver's role. So that's probably rattling through it in terms of the different insolvency regimes that can be invoked. Turning then to retentions. So we talked about Mainzeal before. Andy talked about it from a particularly relevant viewpoint as a liquidator of that particular entity. The failure of Mainzeal, its receivership and then its liquidation back in February 2013, created major issues in terms of claims of subcontractors, and generated the impetus behind putting in place a retentions regime, which kicked in 2017. With all the best of intentions, right? And it's the regime which currently remains in place. And the intention behind it was that money that was retained as required by a construction contract would be held in trust for those who may be entitled to it in accordance with the terms of that construction contract, and not just simply be sort of sucked up as part of the general assets of the company and be dissipated, being used as working capital and being, or used to simply pay other creditors of the company. Great intention, but the problem in practice was implementation. So we found in a subsequent insolvency, the EBIT construction insolvency, where the receivers appointed there had real issues in terms of practically how were they to deal with the retentions regime. And the problems that they had there were that the regime, as currently stands, puts an obligation on the company to put retention money held, to put it in trust. It's an obligation to hold it in trust. But for there to be a trust created at law, that required a number of things to be ticked off technically to achieve that. And if the company had not done that, then despite the best of intentions, a trust would not legally be created. So that was problem number one. Problem number two is if a trust is created, those retentions are not the property of the company in liquidation or in receivership. They're property that's held in trust for, the subcontractor. And as I said before, insolvency practitioners, whether liquidators, administrators, receivers, they only have jurisdiction over the assets of the company, the property of the company. If it belongs to someone else, it's held for someone else, that falls outside their mandate. So what do you have if you are a receiver or a liquidator appointed to a company and there are retentions that are held in trust, legally not the property of the company? What's your jurisdiction, what's your authority to be able to deal with those assets? And that's what confronted the receivers in Ebert. They had to go to court, they had to get a court order empowering them to administer those assets. Third problem is, well, what's involved in doing that? How do you manage the rights to those assets if they're commingled, for instance, and if there's not enough there, as was the case in Ebert, to be able to cover all of the retentions claims? How are they to be paid out? So all sorts of problems have been generated in practice in terms of the current regime we have for retentions. They're intended to be held in trust, but are they legally? There is a tendency for them to be used as working capital if they're not being held in trust as was intended. So as a result of that, further reform of the Construction Contracts Act passed into law in April this year, takes effect, as I mentioned, on the 5th of October for contracts entered into from that date or contracts that are renewed from that date, which tightens up the protections and the implementation of the retentions regime. Gives effect, if you like, to the intention that those monies be held in trust and that those with an interest in those monies have that interest protected as best as can be, and that those appointed as an insolvency practitioner are best placed to be able to, with the requisite authority, deal with those assets. So how does it do that? Under the new regime, money that, under the terms of the construction contract, are required to be held as retentions will automatically be deemed to be held in trust. So you don't have to worry about the issue of the company not doing what it should do to create the trust. The law says it is a trust, so it's held in trust from the outset. It's to be paid into a separate account, designated as a trust account. Now that could be one account for multiple projects, for multiple parties, but it has to be a trust account. And if it is for multiple projects and multiple parties, there's an obligation to keep a ledger under that trust account to record how much is owing, when the money was retained, in respect of what project, and for which party. There's obligations to keep that sort of information so that it can be reconciled, but also to report to those entitled to claim on those retention monies from the outset when the retention is asserted, and on 3-month periods with updates on what the status of those accounts are. And an entitlement on the part of subcontractors on whose behalf that money is held to be able to go and inspect those records and to get information and to verify for themselves that it is indeed being held in a trust account or through a compliant instrument, which is a bond or an insurance policy, but it's there to protect their interests. For how much, in respect of what projects, what the balance is, so there's a proper accounting there. And giving some further teeth to that too, there's an offence created if the company does not do all of these things in terms of making sure that money is held separately and making sure that those accounts are correctly recording exactly how much is held on what job for which people, which gives rise to a penalty not just for the company, but perhaps more significantly for its directors. So that's, when you have a liability imposed on directors, that's when you start getting a bit of traction in terms of compliance of things, right? From an insolvency practitioner's perspective, and these are parts of these amendments which are in place now, if someone like Andy is appointed, then he has the right to be able to administer those funds. He's deemed to be a trustee of those funds and has the authority to administer claims on them and to pay them out in accordance with the entitlements of other parties as set out in the construction contract, etc. The sort of things that weren't there beforehand and the receivers and EBIT therefore had to go to court to try and sort out. And then finally, there's an ability for MB, the Ministry of Business, Innovation and Enterprise, to police all of this, to police compliance with these regimes and to go in there to effectively run an audit and to make sure that that everything is being carried out as it should be. So there's a lot more teeth to the retentions regime under these amendments than previously was the case.